Hi, good day, and welcome to the lecture on confidentiality, which is part of the MDSC 2409 lectures. Again, these lectures should be used in conjunction with the main lectures, okay? Um, Confidentiality is a very straightforward concept. The difficulty some people have with it is recognizing which circumstances confidentiality cannot be applied. Uh, So just going back to the lecture, confidentiality is not a new concept. It goes back to the ancient Greeks and Hippocrates himself, the so-called father of medicine, in whose quote, "Whatever in connection with my professional practice, or not in connection with it, I see or hear in the life of man, which ought not to be spoken of, I will not divulge, as reckoning that all should be kept secret." Right? And then further on, the Declaration of Geneva in 1964, "I will respect the secrets which are confided in me even after the patient has died." And then going back to what we had discussed in the lecture, what is the issue with confidentiality? What if I break the patient's confidence? Well, under normal circumstances, if you confide in anybody and you betray that confidence, the person will lose trust in you, be it family, friend, stranger. The situation is accentuated by the professional relationship that you'll have with your patient, because the patient is coming to you with information that is even more private, possibly than your family, your friends, etc. And if you betray that confidence, that relationship that you have with the patient, the issue again becomes one of trust. And as I mentioned, it's accentuated because it's now a public matter, right? So a lack of trust can lead to the patient not divulging all pertinent information to the doctor, thereby limiting the doctor's ability to provide good care. So you could imagine if the patient doesn't give you everything, all the information you need as a physician to come to correct diagnosis, um, because the profession as a whole has been noted um, not to be keeping confidential information, then we as physicians would find it almost impossible to do our jobs. So yes, confidentiality has its role, but just as a proviso, sharing of patient information can be essential for safe and effective care. We'll see that later on. Patient information is used for medical research, audits, public health and service planning, and patient information can serve the wider public interest, such as disclosures for reasons of public protection. And we are in the middle of a global pandemic, so that's pretty obvious. So the issue is basically, as I mentioned, is the confidentiality obligation as young professionals. Is it absolute? Is it under any circumstances you're not supposed to breach confidentiality, or is it relative? So two clinical examples. What do you do in the case of the HIV positive patient who comes to you in your office and declares that he or she is still having sexual intercourse? Do you betray that confidence and release the information? HIV is still a very heavily stigmatized disease. Or do you respect the confidentiality obligation, say it's absolute, and fold your arms and do nothing, and let this patient be a public health risk basically and go around spreading HIV, to having unprotected sex and spreading HIV? Another clinical situation, what do you do with a new mother with violent impulses towards a newborn baby? Do you sit back and say, declare the obligation is absolute and do nothing and risk harm coming to that child? Or do you report the matter to the authorities? So these are some of this is just the tip of the iceberg basically, right? These are just a couple of clinical cases where the test arises, the test of confidentiality. So in legal terms, the courts will intervene to restrain disclosure of information where the information is confidential in nature and not a matter of public knowledge. So that's pretty much what we as physicians do as well. And where the information is found to be confidential in nature, any non-consensual disclosure requires justification. So in legal terms, in professional terms, we consider confidentiality to be a relative obligation. In legal terms, the courts declare that if you're going to breach confidentiality, there must be some very strong justification for doing so. Just some common law principles continued. Once an obligation of confidence is created, it binds not only the original recipient, so you could be the intern, the house officer on the unit, and the patient declares information to you. Um, and then you discuss that information with your seniors, your consultant, your registrar. All of you are now bound by that obligation of confidence, not just you. Okay. And in the NHS, all staff are subject to laws on confidence, and there's a specific NHS confidentiality policy, right, and a code of practice. So, as ever, as medical professionals, the challenge with respect to medical confidentiality um, lies in determining what amounts to exceptional circumstances. In legal terms, what circumstances will justify non-consensual disclosure, and for us as professionals, when do these circumstances render the confidentiality obligation relative and not absolute. Okay. So you have, in terms of disclosure, you have compulsory versus voluntary disclosure. When you are disclosing information, just some basic rules to follow. Use anonymized information if it is practicable to do so. So you're protecting the patient's identity. Try to inform the patient as much as possible about any proposed disclosure of confidential information. Make sure the patient has ready access to see how their personal information will be used, and keep disclosures to the minimum necessary for the purpose. Right. So as medical professionals, there are certain situations where you must disclose information about the patient, right? So if you're required by statutory provisions, for example, notification of communicable diseases, we have a public ordinance that we discussed in the lecture, and it goes way back to 1915, and that public ordinance states that medical physicians are required by law to report communicable diseases, and we are again in the middle of a pandemic. We're supposed to report cases of COVID-19. Monkeypox is rearing its head, another contagious disease which has been recently declared a global health emergency. So that falls under the ordinance as well, right? Going further into law, if you're specifically required by law, for example, we have a Sexual Offences Act, 2012, Section 31D, and that act says any medical practitioner who has performed a medical examination of a minor, and in Trinidad, once you're under 18, you're a minor, and who has grounds to suspect that a sexual offence has been committed, shall report this to a police officer as soon as reasonably practical, right? So we are bound by this act. And of course, if you're ordered to by the court, if there are court proceedings in a case and the court orders you as a physician who has been looking after the patient to submit information that is necessary for the case to proceed, you must do so by the court, right? So that's compulsory disclosure. So there's voluntary disclosure as well. So with the patient's consent, this is either expressed or implied. So implied within the health, when we say implied consent, within a healthcare team or others providing care, so the patient understands that his or her case will be discussed not by just one physician, but by so in the public health or private health, even the private health setting, there's usually a team of doctors looking after the patient. Sometimes medical specialties may need to confer to get advice on how to manage the patient. So the patient, it's implied that the patient understands that his or her details will be discussed among a team and between physicians, between specialties as well, right, in order to facilitate care. And then the patient, as well as part, it's implied that the patient understands that his or her information, provided it's anonymized, of course, will be used as part of local clinical audit or national confidential inquiries. So we move to disclosure without the patient's consent, right? And these are the exceptional circumstances of it that we're referring to. So if it's in the public interest, if the patient lacks capacity, for protection of the patient, for protection of others, if there's serious crime, and if there are serious communicable diseases. So in the public interest, we discussed this case in a lecture, X versus Y in 1988, where a tabloid newspaper wanted to reveal the identity of two doctors who were HIV positive and still practicing medicine. And the judgment was that the newspapers could not divulge that information on the basis that confidentiality is vital to secure public as well as private health. For unless those infected come forward, they cannot be counseled, and self-treatment doesn't provide the best care. So the case had ramifications if confidentiality had been allowed to be breached. we mentioned the public health aspect of breaching confidentiality. Had the tabloid newspapers been allowed to breach um, these doctors' information and identities, HIV patients in the public would have felt that they could not come forward because they would have feared that their identity would have been revealed as well, right? Um, so on that basis, the identity of the GPs was protected. And we discussed this case as well in the lecture where the psychiatrist sought to review confidential information about his patient who had declared his interest in blowing up and continuing his fetish with explosives, right? If the patient lacks capacity, usually the scene and setting of the unconscious patient, and in this case, discussing the case with family members and fellow colleagues is proper and lawful because it's in the patient's best interest. We talk about best interest in a subsequent lecture, right? Just provisos again, is the lack of just to consider, is the lack of capacity permanent or temporary? So if temporary is a patient on defective alcohol or drugs, and can disclosure wait until capacity is restored, right? But in general, if the patient lacks capacity, you can breach patient confidentiality. For protection of the patient, if a patient lacks capacity and is at risk of neglect or abuse, then the doctor must inform the appropriate authority. We discussed the case of domestic abuse, so it may be appropriate to encourage patients to consent to disclosures necessary for their protection, but you should usually abide by a competent patient's refusal to consent to disclosure, even if their decision leaves them but nobody else at risk of serious harm, right? And we discussed the unfortunate case of the medical student in 1976, right? Tarasov was in the Regents of the University of California. So we move on to protection of others. So serious crime, gunshot and knife wounds must be declared to the police swiftly. We discussed the Sexual Offences Act. That has implications for sexual offences against minors, so protection of minors. New mothers with postnatal depression who wants to kill her newborn infant, and we discussed these two cases and the HIV positive patient who continues to have unprotected sex. So these two, it will come. We could disclose patient information. It comes under protection of others, and then terror threats, of course. And we discussed the Public Health Ordinance of 1915. It mandates that doctors and members of the public are required to inform the relevant authorities about infectious diseases. Right, so I won't go too much into access to medical records for the purposes of brevity and the time constraints we have in the lecture. Just there's something that is we spoke about the issue of genetic confidentiality as well. BRCA gene and Huntington's disease. Do doctors have a responsibility to disclose information to patients' family members if there's a genetic aspect of inheritance to a serious disease? Huntington's, as you know, has a 50-50 chance of being inherited. BRCA gene anywhere between 65 to 70% for inheritance. So do we have an obligation as physicians to breach confidentiality to the patient's family members if the patient refuses, right? And disclosure after death, just to mention, GMC guidance states that your duty of confidentiality continues after the patient have died. This is general guidance, but it really depends on the facts of the case. It depends on the sensitivity of the information, the effects of disclosure on the family, if there's any family remaining. Is the information already in the public domain? And can the information be anonymized? And then, of course, if required by law, you must disclose information to aid the coroner with inquests on death certificates and when a third party has local access to patient records. Okay, so this completes our brief summary of medical confidentiality. Thanks for your attention, and I'll see you for a subsequent lecture. Thank you.